very good day, Mr. Diva. My name is Adriana, Natasya, Safian, Mazni, my metric number is 27325. Today, our firm will explain basic information about trial proceedings and how to give testimony in court and expert, along with the questions that they will be expected to answer in trials. So, when the court is any scientific information that is most likely to be outside the scope of the judge's experience and knowledge, the expert evidence is admissible. So, expert evidence is usually provided by the expert since they rely on the knowledge and experience in which they refer to in the evidence. Usually, the person that will give the expert evidence would be those in the medical field, such as the pathologist that will carry out the postmortem of the deceased person and will give the report to the court as an expert evidence. So, as stated in section 51, if the opinions of living person is relevant, the grounds of the opinion based on it are also relevant, because when an expert provides no justification for his opinion, his evidence would be disregarded. So, section 45 basically laid out the circumstances or categories in which the expert opinion evidence is admissible, which are on the matter of foreign law, such as the identity or genuineness of handwriting in the documents, and the finger impressions, where in the case of fingerprints are the only form of identification against an accused person.
A very good day, I bid to Mr. Tevan. My name is Koh Yuen Han and my metric number is 274056. I will be presenting the part of Rules Governing Opinion Expert Evidence. Section 45 of Evidence Act 1950 is a legal provision that defines what is opinions of experts. Subsection 1 has stated that a person who is skilled give an opinion, and such opinion will be taken by the court as a relevant fact which allowed the court to form an opinion upon a point of foreign law, science or art and handwriting. Subsection 2 has recognized such person as expert. In foreign law, our local court will not make a decision if the dispute involves a law of another court which the local court is unfamiliar with. Referring to in the estate of Eng Siu Guan, the decision of the local court is to accept the Consul General of China's testimony, and this is the law applicable in China, where the Chinese man is allowed to divorce his second wife if she disobeys the first wife or against the family rule. Next, science or art. Notably, science and art cannot merely be regarded as purely science or art in law. In Chandra Sekaran and others MPP, the court has stressed that science and art is flexible to allow liberal interpretation, so the court should accept expert evidence if the matters fall outside Section 545 of EA. Lastly, handwriting. There is a general rule where the court will not fully rely on the opinion of an expert in handwriting. This can be seen in the case of Muhammad Qasim bin Yatim MPP, where the court held that it is a settled law that evidence by an expert in handwriting can never be conclusive evidence. That is all from me. I will pass to the next presenter.
A very good day to all of you. My name is Ka Yao, metric number 272807. I will present the part of determining an expert. In every expert witness trial, it is important that the expertise of an expert must be established before his expert opinion is admitted in court. This involves proving that the expert person is indeed an expert in the field he is called to testify, or testifying in the relevant field of expertise, and demonstrating that his opinion is premised upon that expertise, skill, or training. There are several ways that how the court determines the expert, as laid out in the case of Junandi bin Abdullah against PP. First, does the nature of evidence require special skill? And second, if so, has the witness acquired the necessary skill either by academic qualification or to express an opinion on the matter? Therefore, as a medical expert witness, when you come to court to testify as an expert, the first thing to do is to explain your qualification of an expert in the matter. For example, you may explain your educational qualification, your license, or whether you have attended any professional association and training. If you fail to explain your qualification, the lack of qualification on the part of the expert will affect the weight of the evidence rather than its admissibility. So therefore, it is crucial to explain your qualification as an expert to the court. So that's all from me. Thank you.
Good day everyone, my name is Amelie. My metric number is 272767. Today, I will be discuss the procedure of giving expert evidence in court and the requirement of corroboration. Firstly, the procedure of giving expert evidence in court involves the expert establish their expertise by relating to their qualification, experience, and spatial skills. They should also mention the number of instances where they have given expert opinions in court and the period during which they have testified. They may be questioned by the opposing party and be asked to explain their opinions or answer hypothetical questions based on expected facts. Secondly, let's talk about the requirement of corroboration. Expert opinion evidence alone is not considered conclusive proof, as seen in the case of PP versus Muhammad Qasim bin Yatim. Corroborative evidence is necessary to support the expert opinion and secure a conviction. For example, handwriting analysis by an expert is only opinion evidence and cannot be deemed conclusive. Corroborative evidence is seen as supporting rather than derivative, and the court can reject expert evidence if there are other facts that contradict it. That's all for my presentation. Now I would like to pass the floor to the next presenter.
So in trials, doctors' opinions are accepted in court, but what other types of questions would they be asked? So the doctors will be put through examinations in trial, i.e. Examination in chief, cross-examination and re-examination. So during the examination in chief, the question will be only direct questions. For example, introduce the doctor's identity, qualification and explain the medical report and etc. The doctor must explain each component in their medical reports that were produced as exhibits in court. So next, in the cross-examination, the opposing counsel will ask leading questions to impeach the doctor's credibility and disputing the doctor's report. In this stage, only yes or no answers are accepted. The doctors need to be very firm in answering to avoid being shaken by the opposing counsel. Next is the re-examination stage. It is quite easy as the counsel will only ask the questions that they felt needed more explanation. During the cross-examination, there might be few questions that the opposing counsel managed to impeach the doctor's opinion, but it can be recovered during the re-examination. So the doctors must be confident and meticulously explain themselves and the medical reports throughout the 3 stages of examinations. Doctors' opinions in strengthening their reports might help the innocent party to win the case.
A very good update to Mr. Tevan. My name is Siti, Nurhanis, Suraya, binti Sulaiman. My matric number 273111. So, does an expert witness hold any duties relating to his opinion? The answer is yes, they do. Generally, the functions of calling an expert witness is to help and to assist the court in determining and settling the case by giving opinion which is objective and unbiased in relating to the matter within their expertise. So this is what the court has been stressed about when an expert is being called to the court to come and give his testimony, and the expert in helping the court should act as impartial and objective in a manner as he can. In short, the duty owned by an expert witness is impartiality, independence, and also absence of bias. So the first one, the expert opinion must be impartial in the sense that it reflects an objective assessment of the question at hand. Second, it must be independent in the sense that it is the product of the expert's independent judgment, uninfluenced by who has written him or her or the outcome of the case. Thirdly, it must be unbiased in the sense that it does not unfairly favor one party's positions over another. So the test for the court to determine the expert is whether the expert opinion would not change regardless of which party written him or her.
In conclusion, the person that gives the opinion as the expert must follow the necessary rules and the procedure in giving the expert evidence. However, prior to give the expert evidence, it is important to note that in order to become an expert, the person also must be fulfilling all the requirements of qualification expert that needed, such as if the person is doctor, he must acquire and completed the medical education in medical school, complete the period training, and also is a certified doctor, such as in Malaysia is registered under the Malaysian Medical Council. It is important because in order for the expert evidence to be admissible in the court, the person must be qualified as an expert. So that's all from our firm. Thank you.